I want to talk to you now about how biased and unfair the law has become. Let me give you some examples. We used to have a preliminary hearing. This is a hearing that's held prior to the trial where a judge decides whether or not there is enough evidence to warrant even having a trial. We used to be able to call witnesses at that hearing, and it gave us an opportunity to question the accuser. Well, what happened is in the McMartin case, the preliminary hearing lasted about a year and a half. Most preliminary hearings last a day or a day and a half. The prosecution put a proposition on the ballot to change that, and now they don't even have to call the child in one of these cases. A police officer can get up and testify at the preliminary hearing on behalf of the child. Further, we cannot call witnesses. We used to be able to. So if there was a reluctant witness who wouldn't talk to our investigator, we could put them on the stand at the preliminary hearing and learn what they had to say. Now we can't do that. The next law that is really unfair has to do with sentencing. The acts are parsed down into individual little components. Let's say a child molestation carries 8 years, and the child says, well, he touched me on the left breast, then he touched me on the right breast, then he touched me on the vagina, and then he touched me on the left breast again. Well, there's 4 counts at 8 years apiece, and that took about 15 seconds. That is why you hear about sentences of 400 years and up. The law is designed to usually require that each act be served consecutively and not concurrently. Time the judge's hands, which means that you add one sentence on top of another for each count. Each year there are more and more laws covering this area, and they are designed to make it easier to prosecute and require more severe punishment. For example, people who would go to state prison get 50% credits for good time, work time, but not for sex cases. They have to serve 85% of their sentence. That's an effective increase of 70% more than you would spend in prison, even though there's been no change in the law having to do with the length of sentence of each count. What else has happened? Discretion is being taken away from the judges. Most allegations can be filed as mandatory prison sentences, with just a few exceptions. If force or duress is used, you can get a mandatory prison sentence. Well, when the legislature passed the law and it said child molestation with force, I think they were thinking about real force. Well, the Court of Appeals has stepped in and interpreted what force means. And basically, it's the physics definition. You know, if you push a penny across the table, that takes force. The cases that I've seen, there is only one case that is held not to be force. And in that case, the victim said that she opened her eyes and a penis was in her mouth and it was pulled out. And the person didn't touch her with his hands in any way. Held no force. However, there are cases where somebody was led down the hall by the hand. Held to be force. A case where somebody was placed on the bed. Held to be force. A case where somebody put a hand on the shoulder to guide the head of the child towards a penis for oral copulation. The placing of the hand on the shoulder was held to be force, and that made it mandatory state prison. But what's duress? Duress is another way you can get mandatory state prison. Duress is when you're forced or threatened to do something. You know, if you don't do it, I'm going to kill you, that type of thing. Then the Court of Appeals got involved and started interpreting what duress means. There's actually a case where it came down to, well, he was big and I was little, and I felt intimidated by that. So mere difference in size has been held to be duress. You've heard about the 3 strikes and you're out law? Were you aware that there's a 1 strike and you're out in sex cases when you have penetration with force? 1 strike and you're out. 25 years to life. The other area of imbalance in the law that has developed had to do with the evidence code. We've spent hundreds of years developing the evidence code based upon only allowing in evidence that's reliable. Well, they've made a series of exceptions to the hearsay rule to assist in prosecuting these types of cases. If a child tells a doctor what happened and the child's statements are used in his diagnosis, the hearsay statements are admissible. It doesn't seem to matter that there is no such thing as a diagnosis for sexual molestation. Remember, sexual molestation is an event, not a medical exception. That's an exception to the hearsay rule. They just made one after another, exceptions to the hearsay rule. But no exceptions have been made to help the defense. The Supreme Court in Crawford versus Washington has placed some limits on the ability of the state to make hearsay exceptions. The next thing is that for over 250 years, propensity evidence has never been allowed into evidence in the state of California. Propensity evidence means that you did something similar to this in the past, and therefore you must be guilty of what you're currently charged with. What the courts found was that people would be convicted for their history rather than for what currently occurred. The courts found it to be extremely prejudicial evidence, and it was never allowed in. Well, guess what? A new law has passed which allows in propensity evidence in sex cases. We also have sex registration. That was a good idea when it started. The police would have a way of keeping track of everyone, but every year that law has changed. At first, you had to register once where you lived, and you didn't have to register again unless you moved. So if you owned a home and stayed there for 30 years, you didn't have to register again. They then changed it, and you had to register within 10 days of your birthday every year. And if you don't, you're going to go to prison. Then they changed it again and said that if you're out of your domicile for 4 days, you have to register. Now think about that. That means if you go on vacation to Hawaii for a week, you have to run down to the Honolulu Police Department and register as a sex offender? That puts a little damper on the family vacation. The last thing, and the one that I think we're going to be struggling with for years to come, is Megan's Law. It used to be that the police had access to this information. Now this information is available at every police station for public viewing. The problem is that if you ever get put on a registry, where do you live? They tell your neighbors. Where do you work? They tell your employer. Every year, more and more laws are passed, and they are always designed to help the prosecution and to strip away the rights of the defendant to defend himself. Another thing I want to mention is the sexually violent predator law. After you have finished serving your complete sentence, they can now transfer you to a mental hospital. But the mental hospital has wires around it, cells, and it looks exactly like a prison. The theory behind it is that it's a civil commitment. If you have somebody who's insane and going out and going to kill everybody with an axe, they can be put inside of a mental institution while they're recovering their sanity. Well, here, they're saying that you're still a violent and dangerous sexual predator, even though you've served your complete sentence. So we're going to send you to a mental hospital. It's a one-way ticket. Very few people ever get out.